Yes, Warwick Soden, Chief Executive and Principal Registrar of the Federal Court of Australia, Sydney-based. And I suppose relevantly, prior to the Federal Court of Australia, was the Chief Executive of the Supreme Court of New South Wales for nearly 10 years, and have the very fondest of memories of working closely with the Law Society in those days. I want to talk about digital court files and digital hearings as an inevitability into the future. We in the Federal Court have an electronic court file, a digital court file. We implemented that program 2 years ago. There's now nearly 24,000 digital court files, and you can imagine how many documents would be on 23,000 or 24,000 digital court files. We worked very closely with the profession to help them e-lodge documents. An e-lodge puts their document automatically, in most cases, directly onto our digital court file. So we have empty compactus in our building now, and we set up the digital court file for a whole lot of reasons. One, to be a more modern way of working, of course, and you can just imagine the changes that it's made in the Federal Court. I can now look at any court file anywhere in the country and any document on any court file from my desk. The judges can look at all of their files and all of the documents on their files from their desk. They can use their tablet to look at documents coming into their file 24/7 anywhere in the world. They get an email, or their staff gets an email when a new document goes onto a court file that's on their docket. The digital file enables us to work nationally in a consistent way. It enabled us to set up the National Court Framework to focus our efforts on the new national practice areas of the court. But most importantly, couldn't have done it without the assistance of the legal profession. Many would remember that we were saying we were going to mandate e-lodgement. We don't need to. We now don't need to. We went through a process of training more than 1,000 members of the legal profession in how to use the e-lodgement system, and I can tell you that when I last looked at it in the month of May, there were 15 paper documents lodged. The rest was all digitally lodged, and now 99.9% of all documents are lodged electronically with the court, and most of those go seamlessly, automatically onto the court file, no processing through a registry. So you can imagine the consequences beneficial that's made in our operations and our costs. But most importantly, and we've made this clear, particularly internally, the digital court file is not the solution to doing things digitally in the courtroom. It's not the solution to digital litigation. That's the next step. We're working on that at the moment. We plan in the future to move to a situation where hearings, predominantly, all hearings, small, medium and large, would be done in a digital environment in the courtroom. Now, that's a large step into the future, as you can imagine, the proposal not to have paper in the courtroom, but from our perspective, it's inevitable. It's just a matter of time. That will require a huge engagement by us with the profession. We're up to that. I think it'll even include a necessity for some re-education of many people through CLE type programs. The College of Law might need to give some consideration to the practical element of how to do things digitally in the courtroom. It is inevitable. So that to us is in the near future, in the very near future, the next probably 3 to 5 years. From my perspective, the consequences of big data systems are looming. One can imagine how that might be used in a situation where There's a lot of facts that might be able to put into a big data application that has stored in it all the law, all the precedent in relation to the consequences of factual situation, and a big data solution could be minutes, not days and not hours, and it's easy to imagine the attraction to business, the customers of the legal profession, to that type of potential solution. So one could even perhaps imagine a shift from the dispute resolution clauses in commercial contracts from arbitration to something that a big data system might supply. Write it down on the back of the door and see what happens in about 5 years' time. So for us in the federal court across Australia, we are now in a digital environment, plan to move, as I said, to in-court digital operation. We're liaising closely with the profession about that. I think our CM6 has set the groundwork for the pre-litigation work. We will add to that how things will be done electronically in the courtroom in the future. It's inevitable, and we're heading down that track. And I think what I'd prefer to do is answer questions about what else might be happening.
Thank you, Warwick. Has the court trialled a digital hearing?
There's been many digital hearings, but only
fully digital.
Fully digital, yeah, many of them. But only in the big cases where a provider comes in, where there's been a whole lot of digital discovery. Yeah, we've had a lot of fully electronic hearings.
And the view of that, the consensus.
I think the general view is they've been necessary because of the bulk of the data. And beneficial in terms of the speed with which things can be located and found and referred to and displayed. Not all the time. Sometimes, even in those big digital trials where there's collections of documents, some of the documents are pulled out manually from folders in the back of the room. But, I mean, when you think about it, the whole logic, and we've just been talking about this earlier this morning, the whole logic of a court book numerically sequenced with a collection of chronological numbered documents will be a thing of the past. You don't need to have a sequential number of documents in a book for a system to find any one of 200 documents like that if they're, instantaneously, if they're individually numbered. So the whole concept of page numbers and sequential numbers will disappear. It's going to be about minimising the activity from the collection of the original data to the use of it in the courtroom and being able to refer to it, display to it, find it instantly. It's inevitable.
You commented about how the legal profession has adapted very quickly to the federal court's online filing. Have there been any hiccups along the way, or has that been relatively smooth?
No, look, I don't think there's been any hiccups. I mean, there's been questions about how it's to be used, and we've helped practitioners with those questions. We've had online help, we've had people on the phones that have helped the profession. I think the best gauge I can give is no one has complained. We've only had good news reports about the assistance that we've given, and no one has complained about the lack of assistance. And it's a very easy system to use. It was designed for the use of the profession primarily. We didn't specify anything other than you log on to e-lodgement, you put some data in for us, that goes straight into our case management system, and it's as simple as browse, attach, send. So the documents come out of your case management systems into our court file.
And what are the benefits that have flowed through to the court as a result of that? Presumably financial?
You can. We now do more with much less. Much more with much less. It was not done for the purpose of saving costs, but we can now do much more with much less. We don't have as many people as we had some years ago. I mean, at one stage we had 470 people across Australia in our court in all up. I think that's now down to about 350. So work goes up, people numbers go down. That's inevitable with the automation that is possible.
Questions? Yeah.
Thank you, Warwick, for your time. It's fascinating that the take-up has been so positive. Can I ask what and I guess this might be a fear that goes across the whole range of technological and digital systems, is what's the backup? Say if there is no power, something catastrophic happens, or not even catastrophic, there's a power failure or the system shuts down inexplicably for any reason. Is there a backup? Is there a plan B for the court system to still function?
Yeah, we've like any business, we've got the disaster recovery backup systems in place, and it was only last weekend that was tested. It all works. It all works.
That's from a recovery sense. Sorry, maybe I didn't ask it clearly. In terms of just functioning, can you function without the digital filing, without the access? How reliable?
Yeah, yes, we can. We've actually tested that. What you can actually do is, rather than rely on the system, you can download the file to a laptop for use in the courtroom, and some people do that. So, yes, yeah. But if the whole system went down, we don't have paper files, but we're working on the assumption the system won't be down for that long, that we won't be able to resume business operations within minutes.
I had two questions that I wanted to raise with you. The first one, in relation to the move to digital litigation, does the Federal Court envisage that trials will actually be broadcast, that somebody would be able to sit at home, log on and effectively watch a trial being conducted? So the first question. And then the second question is, when you talked about big data, is the idea there, and I appreciate this is sort of looking a bit into the future, but is the idea there that the court would be able to effectively look at its previous decisions, the precedents, and be able to get far greater guidance as to how a case should be decided when the new case comes in? Is that the concept?
Big data, first of all. There's been no thought given yet to the court using big data. I think the application of big data would be more likely to be provided by law firms to customers. And I think big data is more likely to give probable solutions rather than testing court outcomes, if I could describe it that way. And your first question, sorry?
In relation to the digital trial, whether the Federal Court would be broadcasting those trials.
Sorry, of course. I think it'd be fair to say that the Federal Court's taken the lead across the country historically in televising what we do. And I know we were the first court to produce summaries of judgments and broadcast the summaries, and that's routine in other places now. We've given some thought to televising proceedings. There's some issues there with how to select proceedings. The media, of course, would like to make that selection, and that might not be the best case to broadcast. There's no firm view internally at this stage about broadcasting whole proceedings into the future, but that may well change. That may well change. Particularly with everything being digitally recorded potentially, and it's not at the moment. It's not they're not videoed digitally across the country. That may well change, and that might open up some other options for broadcasting. I wouldn't exclude that. I'd just like to ask about collecting court fees. I presume they're going to go down, things are getting so much better. But can I ask, you must have an interactive ability to collect court fees on documents as they are filed? Yes, that's all interactive now. All the court fees are collected through the e-lodgement process in the same way you pay fees when you book online for an airline ticket. Simple as that. But I do emphasise we have no control over setting the court fees. No control. Now, the one thing that it maybe is a little bit unusual, I'd like to table for the committee's consideration a little video. I know some of you have seen it. It's called The Electronic Court File, A Quiet Revolution. That's tabled for the inquiry's consideration. That was done about 2 years ago, primarily for internal purposes. all the people in it are our people, both judges and staff. Staff playing the role of members of the legal profession who actually are members of the legal profession. But you will see it's a representation of the change from the old to the new, images of courtrooms full of paper to images of people working in the courtroom with no paper, in particular the judge.